Welcome back to Hexen Studios. I'm Scott Dunn. I'm here with Combs Waterkotte, the leading criminal defense firm for all of Illinois and Missouri. Today we're going to talk to Josh Boardman about DUI charges. So what is the BAC limit for DUI charges in Cook County or Chicago, Illinois?
Yeah, certainly. Cook County, along with the rest of Illinois, the BAC for personal driving, non-commercial driving, is 0.08. If you have a commercial driver's license or a CDL, or if you're under the age of 21, there are different BAC parameters. For example, with a CDL holder, the BAC that is, if you are over it, and you would be in violation if you're over 0.04 instead of 0.08. Wow. So they hold certain classifications of drivers more accountable from a BAC standpoint.
Is a DUI a misdemeanor or a felony in Cook County?
A first-time DUI in the state of Illinois is a Class A misdemeanor. However, the more that you accumulate or the more convictions that you have, you can move into felony classifications. For example, aggravated DUI would be if that's your third DUI or third DUI conviction or greater, you can move into that felony realm.
What is an aggravated DUI in Illinois law?
Under the Illinois statutes, aggravated DUIs are enhanced, essentially. There are different circumstances that can bring about, bring them within the purview of aggravated. For example, were you pulled over and charged with driving under the influence with someone under the age of 16 in the vehicle? Would this be your third or greater DUI? Was there an accident or injury associated with the DUI ticket? So under the statute, there's several clarifications. Basically, it's behavior beyond just driving under the influence.
Can a DUI be reduced to reckless driving in Cook County?
It can. So that would be done through the negotiations of your criminal defense attorney. It can be done through an evaluation of evidence. Many times, the state's attorney will get the information from law enforcement, and there may be issues with the stop. There may be issues with circumstantial evidence that would demonstrate maybe a lack of impairment or lack of evidence that they were actually under the influence. And so you can utilize those types of points to negotiate away from a DUI to a reckless driving or something like that. It is rare. It is not expected, but it can be done based on diligent negotiation with the state's attorney.
Can I be charged for a DUI even if I wasn't driving in, say, Chicago?
You can, and we do get a lot of calls on this. Like, kind of a comical one that we will get is someone was asleep in a parking lot, but they were behind the wheels, and they were able to exercise dominion or control, or they had the ability to, from that vantage point, drive the vehicle or operate the vehicle. And so they may say, well, I wasn't actually physically driving, but based on circumstantial evidence, the law enforcement can still write you a ticket for DUI. So don't fall asleep in a parking lot.
Just get in the passenger seat.
Just get in the passenger. Throw your keys out the window.
Right. Can I get a DUI on private property in Cook County?
You sure can. So any of the restrictions on driving under the influence that would be imposed on you as a participant in driving on Illinois or Cook County roads, those same restrictions on levels of impairment would also apply on private property as well.
Wow. Can passengers be charged with a DUI in Illinois?
Generally, no, because there has to be evidence that you were operating the vehicle or had the opportunity to operate the vehicle.
Reached out and grabbed the
generally
wheel.
Passengers are safe from DUI style tickets. I mean, there's still open container violations and things that can be attributed to having booze in your vehicle potentially, but they're not going to be the one that's the primary recipient of a DUI ticket.
What's the difference between a DWI and a DUI in Illinois?
Well, DWI stands for driving while intoxicated. DUI is driving under the influence. And some of that's largely semantics or what the state has identified from their definitions or terminology. For example, in Missouri, the same conduct is called a DWI, but in Illinois, it's called a DUI. So they essentially mean the same thing. Different states have different terminology.
Can a DUI be charged without a blood or breath test in the Chicago, Illinois area?
Yeah, the law enforcement can rely on circumstantial evidence. Did the law enforcement officer detect the scent of alcohol? Was your driving behavior erratic to where it could, it could be supported, or there's a notion that you were driving under the influence? Did you consent to field sobriety testing, like walking the line or ABCs backwards and failed those? Or did you fail an eye tracing test? So there's circumstantial evidence of this, what we would call impairment or influence, that can be derived without a breathalyzer test or a blood draw.
And what happens if my DUI involves an accident in Chicago?
Well, there's different views on that. So one view is, did you cause an accident only? Was there just property damage? Or did you cause an accident based on your, let's call it your impaired driving or driving under the influence that actually caused physical injury or to someone else? Then or did it cause death? And so the accident, the nature of the accident and the results of that accident can escalate it from a misdemeanor charge to various felonies based on what occurred in that accident.
Let's talk about police stops and arrests in the Illinois, Cook County, Chicago area. What does it take for Chicago police to arrest me in the Chicago, Illinois, Cook County area?
Well, to back up a little bit, for a stop, the officer needs reasonable suspicion. So, I mean, that can be a number of things. I mean, that can be, driving style. That could be other types of circumstantial evidence, where you're leaving from, etc. For an actual arrest, you do need to rise to that level of probable cause, and probable cause could be, the scent of alcohol on someone's breath. Basically, you could be arrested if you do consent to, breathalyzer tests or field sobriety tests, and the officer is able to, quote unquote, make the case based on either blowing and blowing over or what they deem to be a failed field sobriety test. Or if you refuse those things, there's implied consent laws as an operator of a vehicle on the road. So if you refuse those things, they can automatically place you under arrest and then base their report on allegations or circumstantial evidence.
Can the Illinois Chicago police pull me over without probable cause?
What they need to pull over a driver on the road is reasonable suspicion. So reasonable suspicion could be erratic driving. Reasonable suspicion could be other officer observations, but probable cause can be obtained once they are actually conducting the stop. To conduct the stop in the first place, they would need reasonable suspicion.
Do I have to answer questions in a DUI stop in the Illinois, Chicago area?
You don't. So my advice generally when clients call about this and ask that question, because that's one of the biggest questions, is what do I say? What do I do?
Yeah.
I always tell them, freely answer pedigree information, meaning, your name, the status of your license, if you are a valid license holder, provide insurance information, maybe your address. But beyond that, they are going to be asking you questions that you may deem to be innocent. For example, where you been tonight? What are you up to? It's a great night out here. Where are we headed? Those types of things, they may seem like innocent questions, but a lot of times it's the officer searching for circumstantial evidence that would allow them to then ask questions regarding potential impairment or operating the vehicle under the influence. So, long answer, is that. Short answer is you're not required to answer questions.
Name, rank, serial number.
Correct. Yeah. Yeah.
Do I have to perform a field sobriety test in the Illinois Cook County area?
No, you don't. You need to understand, though, that if the officer asks you to submit a blood alcohol content breathalyzer test and you refuse, or the officer asks you to participate in field sobriety testing and you refuse, then you can be arrested at that point. It's essentially an implied consent as an operator of a vehicle that if you refuse those, then they will take you they can take you into custody, arrest you. Also, there's implications on your driver's license. I mean, it's a difference between a revocation of your license versus a suspension of your license. But yeah, you do not have to participate. In fact, if you don't participate in their requests, you're not giving them anything to use against you later on in the case.
Are field sobriety tests required in the state of Illinois?
They are not required to be participated in.
Okay.
So whenever you're the subject of a DUI stop and the officer asks you, do you want to participate in the field sobriety testing, or I'm going to have you step out of the vehicle and participate in this, or if the officer asks you to submit a breathalyzer test, you do not have to consent to that. You just need to understand that you will likely be arrested because you refuse those things.
Do I have to take a roadside breath test in the Illinois Cook County area?
You do not have to take a roadside breath test. It is your right to reject or deny or not consent to that kind of testing. You just have to understand that where you do not participate in their roadside breath test or breathalyzer test or anything like that, you've got to understand that whenever you do not participate in those things, they have the right to arrest you, and so you need to anticipate that that'll likely happen.
Can the Chicago police arrest me without test results in the Illinois area?
They can. They'll be required to rely on circumstantial evidence in order for that case to stick, essentially. Circumstantial evidence can be, did they view open containers in your vehicle? Circumstantial evidence can be, what was your driving patterns leading up to the stop? Circumstantial evidence can be the smell of alcohol on your breath. So even if they don't have a breathalyzer test or a blood draw, they can still try to prove that case through circumstantial evidence.
Can the police search my car in a DUI stop in Illinois?
There needs to be probable cause, and that can be gained through answers that you, as the subject of the stop, give to the law enforcement officer. Probable cause can be gained through what's called open and obvious. So is there contraband? Are there open containers? Is there something in the vehicle that would demonstrate that the law is being broken by driving your vehicle under the influence? Also, and then they can search your car with consent, and oftentimes they'll try that first. So yes, they can search the car in that probable cause or through probable cause or consent.
How long can the police detain me during a traffic stop in the Chicago, Illinois area?
For a reasonable amount of time, and that's there's not a sort of black letter law on, but I mean, in order for them to effectuate the questions that they have, the testing that they anticipate doing, I mean, they can't unnecessarily delay you to try to cook up or generate, facts or statements to support their efforts to, charge you or write a ticket for a DWI.
It sounds conditional and unconditional at about the same time.
Yeah. So they cannot waylay you with the motivation of trying to generate a case.
Which creates legal defense for it.
Yeah.
Are DUI checkpoints legal in the Illinois Cook County area?
Generally, DUI checkpoints in the state of Illinois, they need to be announced within conditions. And what I mean by that is they have to be publicly announced. They cannot be randomized. They've got, otherwise they're generally not allowed.
What if the Illinois officer didn't read me my Miranda rights?
That can create let me back up. Everyone thinks that they are able to beat a case because of either the timing of the reading of the Miranda rights, or they claim that the Miranda rights were not read. But whenever we get a case, we immediately search for potential suppression issues based on the Fourth Amendment of the Constitution, search and seizure laws. And so, we'll see whenever the defendant whenever the defendant was in custody and being placed under arrest, when were those Miranda rights read? More often than not, law enforcement does operate in accordance with the state and federal law on those topics, but we analyze every single case that comes through the door for Fourth Amendment applicability.
Well, let's talk about the Cook County DUI court process and the timeline. What happens after a DUI arrest in the Illinois Cook County area?
So after you get arrested, chances are they'll take you into their local precinct or police station or wherever it was that you got your ticket and subsequently placed under arrest. Mm-hmm. At which point in time they will, if it's just a misdemeanor, a lot of times they'll fingerprint you, book you, release you. On other styles of cases, maybe if it qualifies as a felony case, they can, under the Safety Act in Illinois, hold you for up to 48 hours. And the purpose of that is to determine whether or not what charges are going to be filed, and then also it gives the opportunity to the state's attorney to file a petition to detain that defendant pre-trial. So if it's a misdemeanor DWI, chances are after the arrest they're going to what we colloquially call book and release.
So just get you printed and get you out.
Correct.
Where are DUI cases handled in the Illinois, Chicago area?
Chicago, like the rest of the state of Illinois, has a courthouse where the criminal case is going to be facilitated, where you're going to have your appearances, where the judge is going to be. Mm-hmm. So for each county that you get a charge in, you'll be required to go to your court date at the local courthouse, which is typically just kind of the county seat. But mm-hmm. Chicago operates in the same manner. Chicago is different based on its population. They have different courthouses that handle different types of cases. So they may have a felony courthouse, they have a dedicated domestic violence courthouse, and then they'll have a DUI, then they'll have DUI dockets within a courthouse. But generally speaking, all DUIs as misdemeanors and felonies are going to be handled at the courthouse or at the criminal docket that is within the county that you were issued the ticket.
What happens at a DUI arraignment in the Illinois, Chicago area?
So an arraignment is one of the very first steps in a criminal case proceeding. Mm-hmm. It is an opportunity for the defendant to stand in front of the judge and the judge to read them the allegations that support the charges that the state's attorney has levied against them.
Do I have to appear in court for DUI in the Illinois Cook County area?
You do. Oftentimes there will be a court date on your ticket. You need to be at that court date. If you don't, there can be a warrant issued for your arrest. There can be other financial penalties. It does not shed a good light on you as a defendant if you're already not participating in the legal process. So we encourage everyone to seriously consider attending every court appearance for criminal cases.
How long does a DUI case take in the Illinois, Chicago area?
Yeah, it completely depends. And the factors that can control how long a case takes, what county was it charged in? Is it a more rural county where you don't get as many criminal cases, so there's not necessarily a backlog. It can depend on the complexity of the evidence. Is it something where there was a blood draw and you need to send that blood off and get lab testing to determine, blood alcohol content based on that draw? Are there witnesses? Are there depositions that need to be taken of the law enforcement officer? So it really just depends. I mean, I don't know that I would say that many of them are resolved in under 6 months, and at the same time, I don't know that I would represent that many are still pending after 3 or 4 years. So I think a safe answer that I generally give clients is between 4 and 18 months, somewhere around in there.
Sounds like it's very relevant to severity.
It is. The more
aggravated severity.
Exactly. The more severe the allegations, or the more severe the charges are, meaning was it escalated from a misdemeanor to a felony, the longer it's going to take. And that is controlled by 3 individuals: the defense counsel, the state's attorney, and the judge.
What happens at a pretrial conference in the Illinois, Chicago area?
A pretrial conference in Chicago and Illinois courts generally is an opportunity for the court, the judge, to provide some level of accountability to the progress of a case. The criminal defense attorney is going to appear with their client. The state's attorney is going to appear on behalf of the county. And the judge is going to be asking questions like, has discovery been tendered? If it has, are there discovery disputes that need resolution? The parties may announce that depositions are set to occur or something along those lines. It's also any sort of pretrial suppression issues can be taken up at pretrial conferences. It's a way for judges to keep their finger on the progress of a case as it's moving through the court system.
Can a DUI case be dismissed before trial in a Illinois, Chicago area?
Absolutely. It can be dismissed for a number of reasons. I will start by saying it is uncommon. Chances are that if a law enforcement packet has hit a state's attorney's desk and they have the evidence needed to support the elements of filing a DUI, chances are they're not going to flip around and just dismiss that readily. But it does happen. It can happen because of facts that were discovered throughout the discovery process, or the facts maybe not as supported. Did the law enforcement officer not correctly participate in either the traffic stop or any sort of search and seizure issues later on? It can be dismissed as part of a plea deal if there's other charges that defendant is facing. It can be dismissed. It can be dismissed by the strength of the negotiations of the criminal defense attorney. So, it happens. It's rare, but it does happen.
What happens if I miss a DUI court date in the Illinois, Chicago area?
The answer to that is it depends on your judge, it depends on your reason, and it depends on your background. Some judges will just issue another summons and give you an opportunity to come back to court on a future date without issuing a warrant. Some have a pretty tight leash and will issue a warrant if you don't show up to your first court appearance or a court appearance after that. That can be dependent on, was there an emergency or was there some reasonable reason or why you did not participate in it. But if you don't show up, you run the risk of a warrant being issued.
How long does the state have to prosecute a DUI in Illinois?
On a misdemeanor, it'd be up to a year. With a felony, they would need to, with a felony, they have a longer amount of time. They have up to 3 years to charge a felony.
Will my DUI be heard by a judge or a jury in the Illinois Cook County area?
When you say heard, you mean in like a trial setting?
In that sense, yeah, heard by a judge or heard by a jury.
Yeah, so whether the DUI is charged as a misdemeanor or a felony, it's going to be in front of a judge that is going to be hearing the evidence, be imposing any kind of sentence, going to be calling balls and strikes at a trial if that's what the defendant wants to do. But the choice as to whether or not it is a jury trial or a bench trial is one that is left up to the defendant. So if the defendant feels as though a jury of their peers would not be the most conducive option to their fate, they'll choose a bench trial. Otherwise, typically you often think of criminal cases are jury trials, but the defendant does have the option to choose one or the other.
Really?
Yeah.
That's interesting. I mean, that's also through counsel recommendation.
Yeah, and there's a number of strategy conversations that we will have. Is the case one of legal nuance where we have concerns that it might not be presented to a jury in a way that could be readily understood, and we ask that we only have one finder of fact and one trier of fact be the one evaluating that legal issue? Do we have a very likable or unlikable defendant that has the ability to present well to a jury trial? There's a number of different strategy considerations before making that decision.
Let's move on to driver's license and Illinois Secretary of State issue. What is a statutory summary suspension in Illinois?
Yeah, statutory summary suspension, or oftentimes we just call it SSS, it's
a mouthful.
Yeah, it is. It is their legal process. It's administrative, so it's not criminal. It's their administrative process for taking action against your driver's license based on a DUI arrest. And so 46 days after a DUI arrest, the Secretary of State will oftentimes suspend your license for a period of time, and that depends on, did you blow and blow over? Did you refuse? How many DUI convictions do you have in the past? And so after 46 days, your license privileges will be suspended.
When does the license suspension start in a DUI case in the Cook County, Illinois area?
Part of the paperwork or information that is given to you at the point of arrest or at the time of arrest is going to be a notice of a statutory summary suspension. That paper will indicate that your license will be suspended 46 days from that incident of arrest.
Can I drive if I have a pending DUI case in the Illinois Cook County area?
As long as you are within that 46 or that, I guess, 45 days, your license status will not be reflected as suspended. But after that, they'll send you a letter basically giving you a hard date in which your license will be suspended.
And can I challenge a statutory summary suspension, an SSS?
Yeah, and that is one of our
Illinois
strategies that we often do. So what we file in our office is a petition to rescind that statutory summary suspension. And that petition will be heard in front of the judge. And so in that petition, the allegations or the supporting evidence that we present on behalf of our client at those hearings would be issues that, evidentiary issues with the stop, different things like that. And sometimes, and it's typically a point of negotiation or leverage, the state's attorney will confess those petitions and tell the judge, hey, we're confessing that petition to rescind. We're in agreement that the statutory summary suspension should be rescinded, and then that'll be sent to the Secretary of State's office. And oftentimes, you'll see that for first-time DUI recipients where there's not a significant history of violating the statutes while driving. Someone with a clean driving record tends to get a friendly bounce more often.
It's better.
Yeah.
It's better when you have a repeat offender.
Exactly.
How do I rescind my license suspension for DUI in the Illinois, Chicago area?
Yeah, you have to ask for it. And you have to ask for it, and that hearing has to occur within 90 days of that arrest. So often what we file on behalf of our client is a petition to rescind the statutory summary suspension. That petition was filed in the same case that the ticket was issued under. It's filed in the same county. It'll go in front of the same judge, and we will essentially argue based on evidence. Is there a lack of evidence of impairment? Was there something that did not occur correctly in the stop? Various things. I mean, each case is a factual determination, but will go argue that in front of the judge that the statutory suspension should not be put into place and that should be rescinded. Now that's a civil remedy, and it's different than the criminal penalty, which is you're there on the misdemeanor. Secretary of State is administrative. That doesn't mean that you avoid criminal penalties.
Can I get a hardship license after a DUI in the Illinois Cook County area?
You can. You have to petition for that or fill out a hardship application for a permit, and they'll evaluate. And when I say they, the Secretary of State, their panels will evaluate the need for that hardship. Are you a single parent that is solely responsible for driving children to school? Things like that. Are you taking care of a loved one? Are you the primary breadwinner in your family? Are there health concerns or circumstances like that? And so you're able to essentially go argue your case or request based on those types of reasons why during a period of suspension or revocation you should still have driving privileges.
Do I qualify for a monitoring device driving permit? This is the MDDP.
Correct. That's the correct
in
acronym.
Illinois.
Yeah. So that's also a determination based on your criminal history, any sort of adverse actions against your license previously. Oftentimes, they treat that program as a benefit for first-time offenders. Those folks have traditionally not shown previous violations for driving laws or driving under the influence or previous convictions for those things. So they get the benefit of the doubt, and they can choose to try to participate in that program.
Do first-time offenders need to get obeyed in Illinois,
like
Chicago
an ignition
area?
interlock type of device?
Right.
Yeah. That is often imposed as a condition of limited driving privileges or a limited driving permit. And there's vendors for that. They want to see proof of installation, and then it's got to be maintained throughout that suspension or revocation period.
What happens to my CDL if I get a DUI in the Illinois Cook County area?
Well, if you are a CDL holder, several things inherently are affected by a charge for a DUI. For one is the threshold, the BAC threshold is lower. So if you're a CDL holder, the BAC that needs to be demonstrated is anything above 0.04 instead of 0.08. Also, with CDL holders, the state government and the federal government hold those drivers to higher standards. So that affects what sort of penalties or sentences can be imposed against you later on in the case. They're called anti-masking statutes or anti-masking laws. And under those laws, you are limited in what sentences can be imposed. That, for example, with a federal masking statute requires that prosecuting attorneys, state's attorneys, judges do not defer imposition of a sentence or do not try to mirror or mask a conviction in those cases. So we tell CDL holders, you can expect that outside of an acquittal or a dismissal or something like that, there is a good chance that your CDL privileges will be impacted.
It's like driving a rocket for CDLs.
Yeah.
It's very dangerous.
Yeah.
Which makes sense that it would be more severe.
Yeah. You're talking about much larger vehicles, much more,
Scary.
Yeah. You don't want those folks.
No, please don't drink and
Yeah.
drive a truck. Can out-of-state drivers lose driving privileges in the Illinois, Chicago area after a DUI?
They certainly can. So many states have sort of an interstate compact where the administrative bodies, for example, in Illinois, it's the Secretary of State, will report back to the administrative body in whichever state your license is issued. So a good example that we see here, since we practice in Missouri and Illinois, is if somebody gets a DWI in Missouri and their driving privileges are subject to suspension or revocation in Missouri, Missouri notifies Illinois, and the law in Illinois is essentially that if the conduct that occurred in Missouri would also be illegal conduct as far as driving goes in the state of Illinois, then Illinois can also take an adverse action against your license through suspension or revocation. And so that is just an example of how, whether that state's Indiana or Kentucky or any of sort of our neighboring states, they report back and forth to each other. So you may have a Kentucky license, but then your privileges in Illinois are impacted and your privileges down in Kentucky may be impacted.
Let's talk about sentencing and penalties in the Illinois Cook County area for DUIs. What are the penalties for a first-time DUI offense in the Chicago, Illinois area?
Yeah, for a first-time DUI offense, it's going to be a Class A misdemeanor, which means that you can, technically under the statute, you can be sentenced up to 364 days in the county jail. So it's not a prison offense, but 364 days in the county jail. Also, you can face penalties and fines up to $2,500. There are other options available for sentencing to the judge or to negotiate. For example, court supervision is oftentimes, we oftentimes try to negotiate for court supervision. What that is a period of time typically agreed upon or imposed by the court that acts as a probationary period. Keep your nose clean. Don't get any new tickets, new charges. Participate in your chemical testing or victim impact style classes that you have to participate in, subject to this probationary period. And at the end of it, the case is dismissed and it's not a conviction on your record. So between court supervision, probation, conditional discharge, there's a lot of avenues for sentencing that the judge has available outside of just jail time.
Is jail mandatory for a first DUI offender?
It is not mandatory on that first time. It becomes mandatory on your second, and at that point it's 5 days or requisite amount of time doing community service. You can argue one or the other, but on a first-time DUI, it's not mandatory.
How much jail time can I face for a DUI in the Illinois, Chicago area?
So on a first-time DUI, it's going to be charged as a Class A misdemeanor. And under the sentencing laws in the state of Illinois, which would obviously impact Cook County, a defendant can be sentenced up to 364 days in county jail. It's not, because it's a misdemeanor, it's not going to be prison eligible.
What are the fines and court costs for a DUI conviction in the Illinois Cook County area?
Those can vary. There are financial penalties under the statute up to $2,500 for a first-time DUI, but then oftentimes courts will have their own court costs and fees and administrative fees and costs that may get attached to either that would get attached at sentencing, and the court provides you with a sentencing judgment or a sentencing order that is inclusive of those fees and fines.
What DUI penalties apply to a second offense in the Illinois Cook County area for a DUI?
As long as there's not any aggravating factors, it is still a misdemeanor. The difference is there's an imposition of a mandatory 5 days in jail, or you can argue for community service. But one of the key differences is that a second-time DUI is coupled with a mandatory requirement for some time in jail.
When does DUI carry a mandatory jail sentence in the Illinois area?
Whenever you start getting to your second, third, fourth DUIs.
Repeat offense.
Repeat offenses, the penalties increase each time. So a second-time DUI is still a misdemeanor, but there's a 5-day mandatory term of jail time unless you're able to successfully argue for community service. Obviously, the more you get, then it goes into a felony perspective, and the requirements become much more tedious.
What probation terms are common for a DUI in the Cook County, Illinois area?
Yeah, oftentimes a judge will impose conditions that are relevant to the crime. So they are not accusing everyone who is driving under the influence of having substance abuse issues or having alcohol issues. That's really not what the accusations are, but they do want to see your participation in programs that curtail that kind of behavior. So a lot of times they require victim impact panels or chemical or substance abuse accountability style classes. So you may have to go sit in a class on a Saturday or participate in some sort of substance abuse program online. Terms of probation may be random urinalysis or drug testing or alcohol testing, different conditions like that, most of which are at least relevant to the crime in which you're facing, which would be the DUI.
Can DUI probation include alcohol treatment or even counseling in Illinois?
It sure can, and it is the state's position and it's the judge's position that conditions, they're not really scare tactics. What they want to do is address any underlying issues that defendant might be facing. And, oftentimes you do hear programs like Mothers Against Drunk Driving, and sometimes those things are required, but a lot of times it's trying to it's their efforts to get to the root cause of maybe someone does struggle with substance abuse issues or alcohol. And so they oftentimes impose those types of conditions to hopefully address maybe some underlying things that could be occurring with that defendant.
How long does a DUI stay on my record in the Illinois Cook County area?
It stays on your record indefinitely. A DUI is not eligible for expungement in the state of Illinois. So it will be on your record, that conviction. Either conviction, recall that there are options available to a judge at sentencing where there may not be a conviction on your record. Now, could arrest records potentially show up on some levels of background searches? Sure. But if you are not convicted through some sort of deferred prosecution or court supervision, then there is nothing on your record. But once you do get convicted, you really do not have an avenue of expungement in the state of Illinois.
Can a DUI be expunged or sealed in the Cook County, Illinois area?
Generally, the advice that I give to my clients is that if you receive a conviction for a DUI, it is not eligible for expungement under the current statutory scheme in the state of Illinois.
Let's talk about evidence in DUI defenses in Illinois, Chicago, Cook County area. Can a DUI be dismissed if the traffic stop was illegal in Illinois?
Yeah, oftentimes the evaluation there is a search and seizure evaluation. Did the law enforcement officer that was conducting that stop, did they follow all the necessary steps that they have to abide by under the Fourth Amendment of the Constitution as far as reasonable suspicion or probable cause or requirements after the stop was conducted regarding Miranda rights, custody versus arresting, all of those sort of buzzwords that fall within the category of the search and seizure or evaluation of the stop. We evaluate all of those factors whenever we get a DUI case in the door. And if there are issues that are presented that we believe to be in violation of the laws on the books regarding what conduct or what rules the law enforcement officer must play by, then we have the opportunity to file a motion to suppress that evidence. And if that evidence is successfully suppressed, then the state oftentimes does not have the ability to prove up their case at trial and meet their burden of proof beyond a reasonable doubt. So cases can be dismissed through that legal mechanism.
How accurate are breathalyzer tests used by Illinois, Chicago area police?
They are, by and large, more accurate than not. But that doesn't mean that we still don't evaluate the last time that they were calibrated, whether the person utilizing that breathalyzer was certified to do so. That can be relevant evidence, especially if the BAC is close to a legal limit to where if there are discrepancies or if there are issues with calibration, that can lead to some doubt later on in the case.
Can breathalyzer tests be challenged in the Illinois Cook County area?
They certainly can for a number of reasons. One was was there an issue with the device? Was it not calibrated properly? Was there some sort of mechanical issue with it that was documented but still utilized? Was the breathalyzer test by the law enforcement conducted in a unlawful or inappropriate way? It goes into it's a question that goes into our evaluation once we receive the evidence in these types of cases. I mean, is it a technicality? Yeah, but we'll still evaluate it as a potential basis for dismissal or negotiation.
What happens if the officer doesn't follow the DUI testing procedures in the Illinois area?
So I'm going to assume by testing procedures, you mean questions or actions that they take incident to an arrest or leading up to an arrest from a search and seizure standpoint, but then also a policies and procedures standpoint. So if they don't follow the constitutional requirements that are placed on them by Illinois law and by federal law, that can be a grounds for dismissal on motions to suppress. And then also cases can be dismissed if there are technical violations as well. I mean, did they not wait an adequate period of time before conducting a subsequent breathalyzer test? Was there not a warrant issued for a blood draw in a correct manner? Was there technical issues with the equipment that they were utilizing? All of those can ultimately lead to cases being dismissed by the state's attorney.
Do the Illinois Chicago area officers need certification to administer these DUI tests?
They do, and they're all the officers that are responsible for conducting those types of tests have to have documented training, and that training presents their eligibility to conduct those types of tests. There has to be documented calibrations occurring every so often with those to make sure that the breathalyzer equipment is within its acceptable margin of error. That way, if you are giving a breathalyzer test and it comes up at 0.082, that's not all that significant of a deviation from the legal limit. So it's important to them to always have training and certification, and it's important on our side, defending the defendant, to confirm and verify that they are certified, have valid training, have valid experience and utilization, and that everything is up to snuff.
Can a body cam or a dash cam aid in the defense of an Illinois DUI?
It certainly can. I have seen many cases where what occurred either through demonstration of a dash cam footage or body cam footage completely deviate from what the police report states. And that may not be a malicious deviation, it may just be an inconsistency. So for example, I've had cases where the reason for the stop is that the law enforcement officer alleges that somebody crossed a center line. Well, we subpoena or we request as part of the discovery process the video from the dash cam footage. And it'll demonstrate maybe there wasn't a crossing of the line that necessitated a stop. So at that point in time, what evidence does the officer have, or where are they able to generate reasonable suspicion if that is taken away from them? And then also too, we've had folks that have their own recording devices in their vehicles present questions that may not have been asked in the right way by a law enforcement officer, or the circumstances alleged in the police report weren't quite as accurate as maybe they had anticipated. So
often,
yeah. So there is video can be good and bad,
right?
But it is helpful to always request any video that's available and square that against the police report that was issued.
What happens if an Illinois breath or blood test is taken too late?
If it's taken too late, and outside the time parameters that are placed on officers conducting the tests, then it can be grounds for challenges, legal challenges through suppression issues or through arguing that reasonable doubt later on. So it's imperative to always evaluate timeframes as part of the discovery process to make sure that any testing was within the applicable timeframes.
Can medical conditions affect an Illinois DUI test results?
They certainly can, and that's something that's often relevant in our cases, especially where there's not a blood draw or there's not a consented to breathalyzer test. There are different medical conditions, and I mean, there's far too many to name,
Right.
but there are medical conditions that the symptoms could, by and large, be confused with impairment. I mean, if you have a medical condition where you may randomly have seizures, or you may that can create erratic behaviors or appearances of impairment or things like that could be confused by a law enforcement officer. So we always, where there's a potential affirmative defense of a medical condition, I mean, we evaluate what the symptoms are and how well those symptoms match the allegations of impairment.
What happens if an Illinois DUI evidence is mishandled or lost?
Well, if there are evidentiary chain of command issues or chain of control, excuse me, if there are discrepancies with how evidence is handled by law enforcement after an arrest, then we can certainly challenge those through pretrial evidentiary suppression type motions before taking the case to trial.
Can an Illinois DUI be dismissed due to lack of probable cause?
Yeah. So, and sometimes that is in an informal manner, meaning we have done our job and put together a summary or presentation of what we feel to be inadequate areas, and present that to the state's attorney. That state's attorney may or may not agree. If they do agree, I've had state's attorneys, basically put their hands up and say, "You're right. We would not be able to succeed on this case on these facts at trial, so therefore I'm dismissing." Sometimes probable cause issues find their way into the contents of a pretrial motion to suppress, and we place that evidentiary question in front of a judge, and we'll let the judge decide. But under both avenues, dismissal can occur based on probable cause issues.
Well, let's talk about marijuana cannabis DUI in the Illinois Cook County area.
Yeah.
Can I get a DUI for marijuana in Illinois even if it's legal?
You certainly can. And the thinking is, I mean, there's no laws prohibiting alcohol consumption in Illinois outside of, age requirements and things like that. So the DUI marijuana charge mirrors the DUI alcohol charge, because the question is, are you impaired? Are you under the influence of something that is impairing your ability to operate a vehicle safely?
And what is the THC legal limit for driving in Illinois?
So it's based on nanograms. So I believe it's 5 nanograms of THC in your system at a time, or something along those lines. They evaluate it, typically through blood draws or what have you.
Okay.
And it'll demonstrate what it was at that time.
Well, can I be charged with a DUI without THC in my system?
You can, and it can be based on circumstantial evidence that's derived from the law enforcement at the time of the stop. So the same signs or cues that a law enforcement officer is going to look at whenever they suspect alcohol involvement, there's an entirely different set of entirely different set of observations or cues that law enforcement will look at whenever they suspect someone of being under the influence of marijuana. I mean, is there unpackaged marijuana in the vehicle that's not professionally stored and transported in accordance with Illinois law? Is your behavior one that would demonstrate impairment? Was your driving behaviors erratic, or impermissible based on the traffic laws. So once again, if you refuse a blood draw or you refuse any sort of field testing, they can rely on circumstantial evidence and still charge you, and still arrest you.
Mm. How do police test for marijuana impairment in the Illinois Cook County area?
Oftentimes it's done via a blood draw that would demonstrate what the THC levels in that person's blood were at the time of the arrest.
Are field sobriety tests reliable in the Illinois-Chicago area?
So
For marijuana use, of course.
for marijuana use, they can still try to glean circumstantial evidence from field sobriety testing. I mean, so they're still looking for signs of impairment, whether that's inability to walk a straight line or reverse alphabet or number systems or things like that. So it can. I don't know that there's a yes or no answer to your question, but it can help build a case based on circumstantial evidence.
I just wonder if they do it like a comedy routine.
Yeah, I don't know. Circumstantial evidence.
How much are they laughing
How many
right now?
open chip bags are in your passenger seat?
How much are they laughing that they're probably
Yeah.
on marijuana?
Yeah.
Can saliva or blood tests prove marijuana impairment?
So they can prove the existence of those things, but then they will need some form of expert analysis or scientific analysis that level of THC in a person's saliva or blood would cause impairment.
Are field sobriety tests reliable for cannabis DUI in Illinois Cook County area?
So field sobriety tests are just a mechanism for the law enforcement officer to make determinations or observations regarding impairment. Mm-hmm. So the fact of the matter is there's not a yes or no answer. Mm-hmm. They just help create, I keep using the phrase, but they help create circumstantial evidence that the officer is going to place in their report whenever they believe someone to be impaired.
It's awfully subjective.
It is.
In that case.
Yeah.
How long does THC stay detectable for DUI cases in Illinois?
Yeah, so without getting into too much scientific nuance or the body's ability to break it down, I mean, it depends on the quantity that's ingested, but it can be days, it can be weeks. I mean, people can show THC in their system, 3 weeks after or even longer through different types of testing. But I would say general answer to our clients is days to weeks.
Can a medical marijuana patient be charged with DUI in Illinois?
They sure can, because it's not necessarily the consideration of whether or not the defendant was utilizing marijuana, but it's more an analysis of was that utilization causing impairment. So a medical marijuana card holder can operate a motor vehicle in an impaired state, just like a non-card holder can.
What if I was in the Illinois-Chicago area and I smoked days earlier? Can I still be charged with a DUI?
So they can try to create circumstantial evidence regarding an impairment, and oftentimes they will ask the question, have you smoked recently? Are you under the influence of THC products right now? They're trying to fish for answers that would help them build their case against you. And a lot of times folks will say, well, yeah, I smoked about a week ago, or I smoked several days ago, or I smoked earlier today. And that those statements can be utilized as circumstantial evidence later for them to try to demonstrate that you were operating the vehicle under the influence of THC.
Are marijuana DUI penalties the same as alcohol DUI penalties in Illinois?
Yeah, for the first time DUI, it's still a Class A misdemeanor. So the penalties it's just the mechanism by which you were impaired, but the sentencing is still uniform, whether it's alcohol or whether it's marijuana.
Can a marijuana DUI trigger license suspension in Illinois?
It can, yeah. And once again, it'll trigger that statutory summary suspension. You'll get a notice of that. and that'll occur 46 days after the arrest.
Can a cannabis DUI be reduced or dismissed in the Illinois Cook County area?
Yeah, like any DUI, whether it's cannabis or whether it's alcohol or what have you, they need to prove where there's not where it's not a BAC violation. They need to prove that you're driving under the influence or driving while impaired. So the case is built based on circumstantial evidence. What did they observe during the traffic stop? What reasons were conducted during what reasons to conduct the traffic stop? What statements were made by the defendant subsequent to arrest? All of those things go into an evaluation of whether or not they can prove the case. And so where there's deficiencies in those, or where there's suppressible issues or weaknesses with the evidence, the cases can be dismissed, whether that's a voluntary dismissal by the state's attorney or whether that's a dismissal through a legal mechanism or a legal challenge that defense counsel raises.
All right, let's talk about costs, long-term consequences for DUI in Illinois, Chicago, Cook County area.
Yeah.
How much does it cost to hire a lawyer for a DUI in Illinois?
There is not a good answer to that question because different attorneys charge different fees, but
Sure.
the general answer is it's going to be based on whether or not it's whether or not it's sort of an initial DUI. Are you a first-time offender, or have you had multiple and now it falls into a felony classification where you're dealing with prison eligibility? So it's based on a case-by-case review. I mean, you can expect to spend for a misdemeanor DUI thousands of dollars on it, because not only is it going to include the attorney's fees for handling the case, not only the criminal case but also the administrative case, but oftentimes the court or the judge will want their pound of flesh by court costs and fees and taxes.
Right,
and
principal fines.
Exactly.
Yeah,
exactly.
You're already in the thousands.
So you can expect it to be a multi-$1,000 incident.
Is hiring a DUI lawyer worth it in the Illinois Cook County area?
Absolutely. It is an incredibly nuanced process between the criminal charge and the administrative side through the Secretary of State. There is an evaluation of the stop. There's an evaluation of impairment. There's an evaluation of your rights during all of that. There is required mandatory participation in the court process. And then there's also mandatory required participation in the administrative process, which may have pretty severe impacts against your driving privileges through suspension or revocation. So I never suggest that anyone try to tackle a DUI case without the assistance of a lawyer.
How much will my insurance increase after a DUI in Illinois?
Well, each insurance company is going to evaluate one of their insured's driving record
risk factors, right?
Risk factors differently. So as defense counsel, I don't have, because we get this question a lot. What's going to happen in 3 months, 6 months, or whatever? And the answer that I give to clients is that where there is a conviction for a DUI, you can expect that to have negative price impacts on your insurability moving forward. That's why it plays into one of the big reasons why we try to negotiate away from convictions. And if a case is not what I would deem trial worthy, one of the things that we're always going to try to negotiate for is court supervision or some sort of non-conviction result, because it's definitely expected that it'll have a negative impact on your insurability.
Will a DUI affect my job or professional licenses in the state of Illinois?
It certainly can. I can't speak for each industry or each employer, but it is a criminal charge with criminal penalties, the first one being a misdemeanor, the second one being a misdemeanor, but after that it is a felony. It could be a felony conviction. So there are a number of different licensing boards or employers that have pretty strict guidelines for who they employ. And, while some may view DUIs as pretty common offenses, it's still a criminal offense that can affect your employability.
Can a DUI affect immigration status in the Illinois Chicago area?
Yeah, it can, because it is a criminal charge against you. And so if you are already in an undetermined immigration status, or you have requirements to abide by the law, or not have any criminal behavior, participate in any criminal behavior, and you get a DUI, then you're likely going to raise red flags through your immigration process, your immigration eligibility. I'm not an immigration attorney, but practically speaking, there are a number of negative consequences that can be affected whenever someone is convicted of a DUI.
Will a DUI show up in background checks in Illinois?
It certainly can, yeah. Currently, under the present iteration of Illinois law, there is not an expungement statute or expungement eligibility for a DUI conviction. So if you are convicted of a DUI, you can expect that it is part of your criminal record and it'll pop up on a background check. Where you are not convicted through a mechanism called court supervision, where basically you're placed on a probationary term of months with the court.
Mm-hmm.
If you successfully complete that, then that case can be dismissed and it's a non-conviction. But even then, certain background searches, and especially federal, can you can see those arrest records.
Can I travel internationally after a DUI conviction in Illinois?
It can create difficulty. We've had clients have a hard time traveling to different countries with a conviction on their record for a DUI, or have to offer supplemental explanations or additional documentation. So, it's not comical, but you do hear of music artists and things like that traveling to Canada or Mexico or different places and getting held up at the border because of DUIs during their touring year.
Or drug convictions.
Or drug convictions, exactly.
How long do DUI consequences last in the Illinois Cook County area?
So I like to differentiate consequences into immediate consequences versus long-term consequences. So an immediate consequence would be would be at sentencing. Mm-hmm. Is it something where you're facing some jail time? Is it something where you have mandatory requirement and probation conditions? All of those types of quote-unquote consequences are immediately addressable, or can be addressable within probationary terms of time, which could be 12 months, could be 24 months, what have you. But the collateral consequences or long-term consequences is if you get a DUI conviction, then that is on your record, and that consequence may not necessarily be I'll have to go to jail. That consequence can be, now I've got to disclose that on an employment background check. So I mean, they can follow you around for the rest of your life.
Let's connect how a DUI affects the CDL in the Illinois, Chicago, Cook County area. What is the legal BAC limit for CDL drivers in Illinois?
The legal limit for CDL drivers specifically is reduced down to 0.04 instead of 0.08. And the reason why, or the public policy reasoning put into place by legislators, is that you are operating these commercial vehicles, oftentimes much larger vehicles, much more difficult to operate, and so they want to hold those folks that have achieved licensing to operate those vehicles to a higher standard and hold them more accountable.
Can a CDL driver be charged with a DUI if they blow below 0.08 in the Illinois, Chicago area?
So it would be based on circumstantial evidence. So yes, you can still be charged if you blow under, if there's other circumstantial evidence that would be at play, or evaluated by the law enforcement. I mean, your outward sides of impairment, different things like that.
Does a DUI in a personal vehicle affect adversely the CDL licensing in Illinois?
Yeah, because the operative fact is whether or not you were arrested for and subsequently charged with a DUI. So as a CDL holder, people often think that, well, I didn't get a DUI in my commercial vehicle, but your accountability to the licensing requirements to hold a CDL, those go beyond whether or not you're operating a commercial vehicle. Those can be if you're operating your personal vehicle as well.
It seems like they'd want to take into account any vehicle operated at any point in time.
Yeah, it's not a question of the vehicle, it's a question of the
Individual,
Yeah,
right.
exactly.
Is the first CDL DUI a lifetime disqualification in Illinois?
Generally, no. Based on current laws in place, a first-time DUI is going to result in a 1-year suspension of your CDL privileges. However, if you are fortunate enough to get another DUI after that, at two, yeah,
Fortunate.
at two or beyond, it is a lifetime suspension of or revocation of your CDL privileges.
How long is a CDL disqualification for a DUI in the Illinois Cook County area?
So in Illinois, if you receive one DUI and you're a CDL holder that is valid at that time, then you can expect that your CDL privileges will be suspended 12 months.
Can a CDL DUI be reduced to reckless driving in Illinois?
So that's a great question. There's two laws that essentially apply in this situation. One would be federal, what we call anti-masking laws, and state anti-masking laws as well. Basically, what those laws control is the state's attorney and ultimately the judge's ability to try to mask or mirror a conviction for a DUI. So those masking laws prevent them from deferred prosecution agreements. Those masking statutes prevent them from offering court supervision or suspending the imposition of any kind of sentence subject to completing whatever conditions the judge may put on you. And once again, it is part of the legislative intent to hold these drivers to a higher standard. So therefore, they do not let states' attorneys and judges provide them with more favorable results. So to answer your question in sort of a more complete manner, no. I mean, they cannot amend it away from a DUI charge as a mechanism to try to reduce the penalty for the driver.
In Illinois, does the refusing the blood or breath test affect a CDL differently?
Refusing it, your CDL is going to be impacted by an arrest. If you refuse to participate in either breathalyzer testing or field sobriety testing, then under implied consent style laws, then you are subject to being arrested because you refuse that testing. So the two are it's cyclical. The two are hand in hand. So
Makes sense.
yeah, where you refuse as a CDL holder or non-CDL holder, where you refuse testing that's being requested, you're arrested. So it's that arrest that is the trigger point for your CDL.
Can I get a hardship or restricted license after a CDL DUI?
You may be able to get a permit or restricted driving permit for your personal driving privileges, but you can anticipate that if you have been arrested for a DUI and subsequently, convicted, that you don't get a hardship for your CDL privileges. You may be eligible for a hardship for your personal driving privileges.
Does a CDL DUI, would they qualify for a monitoring device driving permit or the MDDP?
So if you're trying to maintain your CDL license and operate a commercial vehicle, the answer is going to be no, because you're going to be subject to that 1 year suspension. So it's not as though they say, okay, you're suspended for a year, but you can still participate in a program or install an ignition interlock device and operate a commercial vehicle. The answer is no. Now, what you could potentially do with your non-commercial driving privileges, there may be eligibility, but certainly not for a CDL, for operating under a CDL.
Well, after a CDL DUI, does it automatically suspend my driving privileges in Illinois?
Generally, it is supposed to, because it's triggered by the arrest. Now, when that actually shows up or when that actually occurs, as defense counsel, I don't have any control with the administrative agencies that facilitate that process. But generally, it's suspended upon the arrest, which the arrest would be immediately following whatever allegations of impairment there would be.
Is it in Illinois? Is it mandatory for CDL drivers to report that they've had a DUI?
So they will need to report to their governing administrative agency that controls their license, whether that's at a state level or federal or what have you.
Okay. Can I drive commercially pending a DUI case in the state of Illinois?
So if you're driving commercially because let's assume that you had a CDL, that suspension of driving privileges is going to be based on the arrest. So where it's a little different is your driving privileges under a CDL should be theoretically suspended after that arrest. That's different in Illinois than a non-CDL holder, because at that point in time, they're given a notice of statutory summary suspension, which occurs 46 days after the arrest. So the question is, you may have some what I would call leeway or allowable time to drive as a private non-CDL holder before that you receive your suspension date. Not so with a CDL.
Let's say I'm a CDL driver. What happens to my job after a DUI in the state of Illinois?
Yeah, that's one of the most critical questions that we get calls for is, I am an over-the-road truck driver. I operate heavy machinery, and I'm required to hold this type of license. And oftentimes, it's a pretty unforgiving process. That's why it's important to hire somebody that understands the nuances and the ability to, and has the ability to really pursue a vigorous defense of DUIs by CDL holders, because the collateral consequences of not having a CDL, if that is your main source of employment or what have you, can be critical.
Yeah. Quality of life.
Exactly.
Can a DUI or a CDL DUI be expunged or sealed in the state of Illinois?
Presently, with the law, how it stands in Illinois, there's not a mechanism to expunge a DUI by a CDL holder. It mirrors a non-CDL as well. There's not law in the books that permits that at this point in time.
Now, what happens after a second offense of a CDL DUI driver in the state of Illinois?
If you have got charged with a second DUI and you are a CDL holder, you can expect that you will likely receive a lifetime revocation of your CDL privileges.
And that's it.
So on your first one, it's a 12-month suspension, but beyond that, it's very punitive.
2 strikes, you're out.
2 strikes. Well, 1 strike.
Well, truth.
Yeah.
Truth.
Yeah.
Now, in Illinois, do varying qualifications for a CDL, let's say like box truck driver, or big 18-wheeler driver, does that change the consequences of a DUI?
So the need to have a CDL to operate one of these vehicles is going to be based on weight classifications and things like that. So there may be vans or box trucks that don't require you to have a CDL. And if that's the case, then the CDL, if you're operating one of those vehicles, you're a non-CDL holder, the specifications or the penalties are going to be of that as a personal driver, even though you may be driving commercially. But if you cross into that threshold of weight classifications or vehicle classifications that require you to hold a CDL, then you're going to be held to those higher standards.
Now, you may not be able to or handle situations like this, but the Googlers are curious. What is the temperament for punishment if you're an airline pilot operating a commercial airline while intoxicated to whatever degree?
Yeah, and that's a great question because I think
I saw a movie.
think there's been several. Yeah, and then I think there's been several news articles lately where somebody was operating or was suspected to be drunk whenever they were flying a plane. So obviously you'd be subject to criminal penalties, but also you could be subject to FAA suspension or revocation of your license or clearance to fly. But we don't get a lot of those.
You probably not. That's a deep cavern of cause and effect.
Yeah.
With I don't know, flying while impaired. Can we do another acronym? FWI.
Maybe so. Maybe so.
But Josh, it's great to see you.
Of course.
We appreciate you. We appreciate all the information. We always love having Combs Waterkotte in the studio because the information is so valuable to all the folks that join us.
Of course.
And we're grateful to share it, and we're grateful that you took the time out to come in and visit
Happy
with us.
to do it.
Excellent. Well, thank you so much for joining us. This is Hexton Studios. We had Combs Waterkotte with Josh Boardman, and we'll see you next time.